answer the question I posed earlier to your opposing counsel about, are we to look at the broader question that was dealt with by Judge Chutkan with respect to presidential immunity, absolute immunity for no criminal prosecution of official acts, versus looking at this indictment and accepting as true the allegations that it brought there, or both?
So we have a strong preference that the court adopts the former view and looks at the question in the way of, as the district court did, which is to say, based on questions of separation of powers, of constitutional text, history, precedent, is there in fact immunity for a former president? We think the answer to that is no, for of course all of the reasons we put in the brief, and I'm happy to sort of address here. Candidly, I think if the court gets to that second question, there are some hard questions about the nature of official acts. And frankly, as I think Judge Pan's hypothetical described, I mean, what kind of world are we living in if, as I understood my friend on the other side to say here, a president orders his SEAL team to assassinate a political rival and resigns, for example, before an impeachment? Not a criminal act. President sells a pardon, resigns, or is not impeached? Not a crime. I think that is extraordinarily frightening future, and that is the kind of, we're talking about a balancing and a weighing of the interests, I think that should weigh extraordinarily heavily in the court's consideration.
Let me ask you about the effect of blasting game. What is it? How does it either bind us? How is it persuasive for us?
So I think it formally has no application at all, because of course, very early on in the opinion, the court says we're not dealing with any questions of immunity in the criminal context. I tend to agree with my friend on the other side that in many respects, it does reinforce the nature of the Fitzgerald civil outer perimeter standard. It says you don't look at intent or you don't look at purpose. Context plays a more important role than often the content of communications. I think that the significant change, of course, is the acknowledgement of the looking at a president, whether that president is acting in his or her role as office seeker or office holder. But again, to go back to my response to Judge Childs' question, although that would change the nature of whether may change the nature of whether certain things are or are not official acts in the indictment, we just think that's entirely the wrong paradigm to use. We think under Fitzgerald, in fact, that would be inconsistent with Fitzgerald's reasoning, and also just irreconcilable with the nature of how criminal law works. I mean, to say that we're not going to take account of motive or intent, there are plenty of acts that every day. I mean, for example, if I were to encourage someone not to testify at trial because I wanted to go on a hike with that person, it's not a crime. If I were to encourage someone not to go on a hike because their testimony at trial, encourage them to skip their trial testimony because their testimony was going to incriminate me, it's the same underlying act. And now when you map that on to the presidential context, you come up with some of the frightening hypotheticals where as long as something is plausibly official, even if it involves assassinating a prominent critic or a business rival, that would seem to then be exempt potentially from criminal prosecution. We certainly wouldn't concede that if that's the world we need to live in. I think we would advance plenty of arguments below, but we really, but those arguments themselves would create satellite litigation that are an additional reason not to go down this route.
But looking and thinking about your answer about potentially not looking at motive and intent, when there is a criminal prosecution, that mens rea and that intent is part of the actual statute charged criminally.
Yes, precisely. And that's why it wouldn't make sense to then come in and use this non-motive intent. As I understand how Fitzgerald outer perimeter standard might work, it could say those types of official acts, official conduct, that is something from which the president is immune. You don't ever get to that second question of, well, did that person act then with mens rea? Can we prove it beyond a reasonable doubt? Because it is, at least under a theory where it's not available at trial, then there's no way to reach that conduct.
When we're looking at this indictment, though, back to Judge Henderson's question about the use of blasting game, some of the acts are same or similar, and there was direct discussion of it in that opinion as determining whether it was office seeker versus office holder. So do we use Blassingame at least for that?
So if this court decides the case the way the district court did, then I don't think Blassingame has any role to play at all, because there is no question of whether, was this act official or were these sets of allegations official? The question is, based on a Fitzgerald analysis in case, history, precedent, et cetera, is there any quantum of immunity for a former president? We think the answer to that question is no. There's no reason, as the district court also found, to turn to the indictment and consider this outer perimeter, this civil outer perimeter standard.
How about if we don't decide it the way the district court did?
If you don't, I suppose a lot would.
On the Blassingame.
So there are a lot of different ways this court could not decide it that way. I think to pick up on my response to Judge Childs, we certainly stand by our view in the brief that some substantial number of allegations would fall outside of an outer perimeter, and that I think is enough to affirm. I think either parties are urging the court at that point to then send, of course, the case back to the district court. I think that then would create a series of challenging questions that I mentioned earlier. What are the evidentiary theories under which that evidence could potentially come in? But it would be our strong view, and we would want, if the court followed that route, which we urge the court not to make clear that immunity is an on-off switch, right? This is the immunity appeal. If the court says we affirm, we send it back, there's no immunity, then other things become evidentiary questions or questions really of jury instructions, in which any appeal is then an appeal from a final judgment, if any final judgment.
And the immunity defense is never lost.
Well, I don't think it's immunity at that point. I think this court will, in what I've just described, will have said there is no immunity. There may be some types of other challenges as evidence comes in at trial. But again, I think that would lead to this extraordinarily complicated litigation that is not the top line reason, but certainly among the reasons why the court should not go down that path.
Since President Trump concedes that a president can be criminally prosecuted under some circumstances, he says that that is true only if he is first impeached and convicted by Congress. Do you agree that this appeal largely boils down to whether he's correct in his interpretation of the impeachment judgment clause? That is, if he's correct that the impeachment judgment clause includes this impeachment first rule, then he wins. And if he's wrong, if we think the impeachment judgment clause does not contain an impeachment first rule, then he loses.
So I think that's basically right. I mean, the defendant's theory over the course of this litigation has evolved a bit. And I think now before this court, I understand the argument to be principally sort of the principal submission to be, as you've just described, this, what we call in our brief, the conditioned precedent argument, that there is only liability, criminal liability for a former president if that president has been impeached and convicted. And that is wrong for textual, structural, historical reasons, and a host of practical ones, one of which I'll start with, again, to just amplify the point. It would mean that if a former president engages in assassination, selling pardons, these kinds of things, and then isn't impeached and convicted, there is no accountability for that individual. And that is frightening.